All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Good morning. Please be seated. This is the time set for oral argument in 1CA CR17 0789, State of Arizona versus John Allen Stamm. Counsel, each side is allowed 20 minutes for argument. Appellant may reserve a portion of that time for rebuttal. If you wish to do so, sir, you'll need to keep track of the time on the podium clock. Out of respect for counsel in court, I ask that those in attendance please make sure that your cell phones are off or on vibrate. Counsel, we have read the briefs. We've conferenced this case this morning, and we encourage you to keep that in mind when you present your argument. These proceedings are being recorded. They'll be posted to YouTube, so please, before you begin your argument, please state your name and the party you represent. With that, Mr. Ray, you may proceed.
Please, the court, good morning. My name is Kenneth Ray. I represent John Allen Stamm. Mr. Stamm is present, the bearded gentleman behind me today. And judges, I will tell you that it's been an honor and a privilege to represent Mr. Stamm. He is indeed an icon of the city of Prescott. He attained the iconic status. He's 69 years old, and he attained that status by moving to Prescott in 1963. He attended Prescott High School. He went into the Navy in 1969, served during the Vietnam years, returning and took over his family's business, which was the Birdcage Saloon on Whiskey Row in Prescott. He took that over in 1975. His parents had opened that business in 1969. And things went swimmingly for many years until the second decade of 2012, when a fire destroyed his business and another. It was a building that was owned by former Superior Court Judge Howard Hinson. But they rose from the ashes and reopened at another location at 160 South Montezuma, an address that's been mentioned in the briefs, in 2013. But as time progressed, financial difficulties, marital difficulties, and the personal depression issues of Mr. Stamm converged, coalesced, and combined to result in the events that occurred on October 20th of 2016. Judges, I've only raised two issues in this case. I tried to keep it narrow to the points that I think were of greatest importance to this court and to Mr. Stamm. But as you can gather from looking at the briefs and the transcripts, this was a hard-fought case, raising many issues. But the two that I think that are most critical in the consideration of this case are the consolidation of the two indictments and the use of the acquisition, disclosure, and use of the recorded jail conversations, both from Maricopa County and Yavapai County. Addressing the first matter, the consolidation of the indictments. The trial court relied heavily, if not almost exclusively, on State versus Ferraro, his 2012 Arizona Supreme Court decision, saying that the evidence between the first indictment and the second indictment, which were separated by a couple of months period of time, were intrinsic. And therefore, because they were intrinsic, they were relevant each to each other. And it is that decision, which was repeated many times in the course of Judge Papour's decisions, that we claim was a mistake.
Didn't the court also make an alternative ruling saying, I also find that the evidence would come in, would be admissible under Rule 404B? Under
404B analysis, and the case that sticks in my mind is the Aguilar case and the cross-admissibility of evidence in the two cases. But ultimately, yeah, he did do that, Judge Brown.
Okay.
But as you look through the history of the record in this case, it was based upon intrinsic. I find it to be intrinsic. right down the line.
Also a 404B analysis, counsel?
To some extent, I would suggest that it is. However, the Arizona Supreme Court in Ferraro, in a very detailed analysis, said that it's so confusing that we're going to try and clear this up. And the court said, henceforth, evidence is intrinsic in Arizona if it, 1, directly proves the charged act, or 2, is performed contemporaneously with and directly facilitates the commission of the charged act. And I think what we need to look at, of course, is the second indictment to find out whether the first evidence from the first case is intrinsic to the facts and circumstances of the second case. And clearly, October 20th is the first date, the date in which all these things converged and coalesced to result in Mr. Stamm becoming suicidally depressed, frankly. And he attempted to kill himself and was unsuccessful in that task. And then he went to the hospital. When he was released from the hospital, while he was at the hospital, his wife visited him on at least 2 occasions. The record bears that out in the testimony. Provided him a telephone, implicitly requesting that he have telephonic communication, but kept secret the fact that the state was going to prosecute him for his failed suicide attempt and the events that led to that. It is our position, rightly or wrongly, but it's our position and opinion, that nothing about the events of October 20th had anything to do with, does not directly prove the charges in the later case, which arose in December of 2016.
But let's assume we agree with you that those events were not intrinsic, okay, to the chart under Ferraro.
Yes, sir.
Court got it wrong. Assume for how. What I'm struggling with is the court did make an alternative finding under 404B that evidence was admissible, which is, of course, we're not going to go through all the 404B analysis, but you understand it very well. You have not, to my understanding, have not challenged that on appeal. So I think we're sitting here with the finding of the court that evidence was admissible under 404B. How then do you climb the mountain or overcome the hurdle on appeal to convince us that you've shown compelling prejudice to reverse on this severance issue?
The prejudice points I bring out at pages 19 and 20 of the opening brief. Those are the best arguments I can make for you, Judge, and it wouldn't bear repeating. But I can tell you that the first part of your question is, yes, ultimately the judge had a great deal of effort on the part of the state to get the judge to talk about Rule 404B as an alternative method by which to admit the October 20th evidence. He ultimately relented to that, made his finding that it was a Rule 404B issue and that it was therefore offered for a relevant purpose spelled out in Rule 404B. I suggest that it just wasn't relevant. Nothing about the facts of the October 20th case would have aided in any respect, I respectfully submit, to whether he was stalking, whether he was violating a court order with respect to harassment, and the other charges set forth in the second indictment relating to the December events. Nothing about October had anything to do with that, other than, as I point out in the brief, it had a common alleged victim. That's the only thing that was connecting these two.
Isn't that pretty significant?
I don't think so, Judge, because
let's say that it was somebody else. It was to me that's, I'm not going to say that's a complete game changer, but that is significant. That's significant. He knows they know each other, obviously. Very well.
Very well.
And knows those circumstances, knows the possible motive, the possible intent, the lack of motive. I mean, how are those not sort of key issues under 404B?
Are we to examine both sides' motives? Perhaps.
Perhaps,
I asked
yeah,
that
yeah,
rhetorically,
yeah.
Judge.
Well, your
I don't
client
have
was
to.
in trial, so
Yes,
the
of
state had
course.
the burden to prove beyond a reasonable doubt guilt on the charges alleged against your client. So that, at least if we're talking about what the core issues that needed to be proved, motive would be as to your client and no one else.
Certainly, but there's always a defense to a case as well, which we endeavored during the course of the trial, as you gathered from that, to explain what her motive was, the alleged
And you
victim's
had some
motive.
success.
Some.
It was not, all charges were not proven as alleged, both with respect to some acquittals and some lesser included. But let me come back to Judge Brown's question on 404B. I don't see that being challenged on appeal, the admissibility determination, and it may have been at the 11th hour, but it was made by the trial court. And if I hear your argument right, it is the misjoinder is based on your argument that evidence with respect to the October charges were inadmissible for what I'll call the December charges.
Yes.
That's not the other way around. It's October as to December.
Yes, sir. I believe that's the direction the vector takes in these types of analyses.
Okay.
And wouldn't those October offenses be relevant to proving, let's just say, the victim's state of mind as it relates to the stalking charge from the December charges? I mean, isn't that a possible?
There are any number of possibilities, Judge, and there's any number of ways that one could massage the facts to make it relevant. But what I think we need to really do is examine the true meaning of relevance. Just because facts are out there and exist and could be, through articulate argument, be made relevant, doesn't mean that they are legally relevant.
But relevance is an extraordinarily broad
It is.
concept under 401. I mean, from an objection on pure relevance, if that's the sole objection, as a trial lawyer, I think you would concede that's not your strongest sort of way to push back.
Not in the least. I always want to go back to 403 to argue that it's substantially more prejudicial than probative of the fact that one is trying to prove. And in that context, you must, just as you must with intrinsic, extrinsic evidence, analyze, it still has to be relevant. It still has to be substantially more probative than prejudicial. So you still apply the 401 and the 403 analyses even to intrinsic evidence, in my opinion. But
And I think Ferraro, bears that out.
Sure.
But again, we're in 404B land right now.
well, it's interesting that there's always two bites to the apple, I guess, in these kinds of trial contexts. The state argued strenuously that this was intrinsic evidence. These two cases were intrinsic and, I forget the operative words, but inextricably intertwined. But they just weren't. You could have had a freestanding December case without having any of the evidence of the October case.
But is the test that we're asked to apply, given a fairly deferential standard of review to the trial court, whether something could have been tried on a somewhat smaller body of evidence, or did the trial court abuse its discretion in allowing a somewhat broader body of evidence?
I think the world of Judge Papour. I'm going to miss him when he retires. But on behalf of my client, it is my view that he missed it on this one, with all due respect to him. He ruled initially and repeatedly that it was intrinsic. He then, for whatever reason, but at the strong behest of the state, said that it was 404B. So he...
Well, that really wasn't done at the 11th hour, though, counsel. I mean, I have the record on appeal number 88. The state filed a memorandum and offer of proof regarding 404B evidence in mid-March, and the evidentiary hearing on that issue didn't take place until mid-May. So, I mean, this was known to all parties that the state was trying to seek this for an alternative purpose under Rule 404B.
And I'm not going to dispute the record, Judge, at all. It took the course that it took. With all due respect, judges, unless I really would like to get to what I think is a more important issue, and that is the wire communications, and I'll try to move quickly through that. The operative controlling statutes that I've cited, 18 U.S.C. Section 2510 et sec, can be analyzed by this court by taking into account the long-standing principle in this court that this court may provide greater protection than that afforded by the federal law and the interpretations of the federal law. 18 U.S.C. 2511, A, B, D, and E1 all deal with the interception, use, and disclosure of intercepted communications, which I don't think anybody is taking issue with the fact that when a law enforcement entity such as the Maricopa County Jail staff, the Yavapai County Jail staff, record these calls, they do so, that meets the definition of interception. 18 U.S.C. 2515 spells out, whenever any wire oral communication has been intercepted, no part of its contents or of such communication and no evidence derived therefrom, et cetera, may be used as evidence in any trial, and it applies both federal and state.
But didn't your client consent to the interception of these calls?
He consented to interception, monitoring and recording, as was borne out in the evidence in this case. The recording says this call may be monitored or recorded. It does not say this call may be monitored, recorded, used, divulged, etc. The state pointed out in its arguments as well as in the briefs that Stamm signed a document which stated, I understand, quote, I understand and agree the telephone calls are subject to monitoring and recording and may be intercepted or divulged. And it points to in 1527, the first case, index of record 236. The important language says Stamm signed a document. I ask you, judges, to please look at that document, index of record 236, because you will see that it is not signed.
So let me ask you this. Your argument so far this morning is with respect to the validity of a waiver of an expectation of confidentiality or privacy. But let me go a little upstream from that. What expectation of privacy or confidentiality did your client have, if any, given what I understand are the sort of recorded disclaimers? Hey, if you're going to make this call, understand we're here watching you, we're here listening. What did anything attach given those disclaimers? I mean, was a waiver needed?
The consent, and I think it may go to the consent question that you may have, Judge. The consent is bound, the scope of consent is bound by the consent granted, in my opinion.
And I understand that, but in other words, I may, if I confer with a lawyer, have a reasonable expectation of privacy, and unless I waive that communication, it's mine to hold. But if I have that using a PA system at what used to be called America West Arena, when they're, back in the day, 15,000 Suns games, or Suns fans watching, we don't get to waiver because I've never had a reasonable expectation of confidentiality to begin with.
But while he may expect that the call may be listened to and may be recorded, implicit in that is what was the purpose for the listening and the recording. The purpose was for jail security. That's borne out in the briefs.
And I understand that with respect to waiver, but I'm not with you yet, and help me better understand your argument with respect to the expectation of privacy or confidentiality.
Well, he has his choice. No calls at all with the outside world, or except what it is that the parameters that are defined to him in
Right.
the context of the call.
Right.
I don't think that you can attribute to him this waiver of divulging that was not signed by him. So I think we're limited to monitoring and recording for jail security purposes. What he speaks is in the context of that consent that he has given. Beyond that, Judge, I think things are if the recording had said, and we're going to disclose this to the state in hopes of being able to help the state prosecute you, that would be different.
Let me push back just a little bit one
Okay.
more time, and let me use my son's hypo. If I speak to my attorney at a Suns game and no one else can hear, you need a waiver later. I completely get that because I have a reasonable expectation that that communication is confidential. But if I do it over the PA system, we don't get to waiver because I have no reasonable expectation of confidentiality to begin with. That's the dichotomy that I'm struggling with.
Except I think that the federal statute 2515 is creating that privacy right for you, saying that it can't be used. It can't be disclosed. So it's giving you the benefit of that as a matter of law, not as a matter of practicality in the context of your hypothetical, Judge. So I would encourage you, and I see that I'm out of time, but I would encourage you to examine these statutes, most especially 2515, the fact that there was no waiver, signed waiver, that included this all-encompassing divulging language, but it was limited to that which was on the recording itself. Thank you.
Thank you, Mr. Ray. Ms. Garcia.
May it please the Court, Elizabeth Garcia for the Attorney General's Office, representing the State of Arizona. This Court should affirm Stamm's convictions and sentences because the trial court properly granted the State's motion to consolidate cases and because the trial court properly denied Stamm's motion to suppress his Yavapai and Maricopa County jail calls. I'll first address the consolidation of the two cases before moving on to the admission of Stamm's jail calls. The trial court didn't abuse its discretion consolidating the two indictments because the offenses were properly joined under Arizona Rule of Criminal Procedure 13.3A2. The evidence of the October 20th offenses were relevant to prove Stamm's motive for committing the subsequent harassment, stalking, and judicial interference offenses. They helped to prove...
Let's see. I mean, the 2016 indictment was for aggravated assault,
Yes.
unlawful discharge of a firearm, and disorderly conduct. So what elements of those offenses are relevant, to flesh out the stalking, harassment, aggravated harassment, and IJP charges that were in the subsequent indictment?
Absolutely. So to prove harassment and aggravated harassment, the state had to prove that a reasonable person would have felt harassed by Stamm's conduct. The fact that he had committed the October 20th offenses justified Deborah's reaction to Stamm's course of conduct that harassed her. It proved that she had a reasonable fear for her life, which was relevant to prove count one, the stalking offense, and the existence of the judicial order prohibiting Stamm from contacting Deborah resulted from the October 20th offenses. The state had to prove that Deborah feared for her life, that a reasonable person would have feared for her lives, and it also proved Stamm's state of mind, that he acted intentionally and knowingly, that he would know that his course of conduct would harass Deborah, it would cause her to fear for her life, because he knew of the acts he had committed on October 20th and the effect that they had on her.
Did the Superior Court muddy the water here by relying on Ferraro and the intrinsic evidence? I mean, what is the state's position on intrinsic evidence?
The intrinsic evidence finding was erroneous, but it was harmless in light of the court's alternative 404B finding, which occurred before trial. Stamm also cannot prove any compelling prejudice resulting from consolidation of the cases. As the court,
Counsel,
yes.
before you get to prejudice, and I want to hear about that. You have heard appellant's counsel say that it's the October fact cluster that
Yes.
didn't show the December charges.
Yes.
Under the joinder rules, do we look just one way, or do we have to look at the December charges and see if they are, connected together with their commission as to the October charges as well?
Any claim that they were not otherwise connected, if that the 2016 were not connected to 2017, it wasn't cross-admissible, has been waived by Stamm by his failure to raise it.
And let me,
yes.
If I accept all of that is true, let me ask you then that as
yes.
a hypothetical. Does it go both ways, or do you just look downstream?
We look downstream, but it does go both ways. It would be relevant to prove Stamm's motives for committing the 2016 offense, and the 2017 offenses would demonstrate his consciousness of guilt for committing the 2016 indictment offenses.
I want to hear about prejudice, but not
yes.
quite yet. You had mentioned, or if I hear you correctly, on appeal, the state concedes that the intrinsic admission was erroneous under
Correct.
Ferraro. Isn't evidence received as intrinsic under Ferraro and that same evidence received for a limited purpose under 404B? Those are two different things, aren't they?
Correct.
And so if it's admissible for all purposes under Ferraro, but that was erroneous, but yet under 404B it would be for, by definition, a limited purpose, how do we sort of, unscramble those eggs?
I'm not sure I understand the court's question.
If the evidence was admissible under Ferraro as intrinsic, it comes in for all purposes.
Correct.
If it's admissible properly under 404B, it comes in for a limited purpose. There's a limiting instruction. It can only be used by the jury for, knowledge, lack of mistake, motive, fill in the blank. But it's not the whole panoply of what it could be used under Ferraro. So if we have the same body of evidence admitted under both sort of legs of that stool,
yes.
forgive me, a two-legged stool, and one of those legs goes away, the one that allows the evidence to be considered for all purposes, how do we then kind of deal with, well, it was admissible but not for all purposes, only could be used for this limited purpose under 404B. Given your concession, how do we wrestle with that?
I don't think the court has to wrestle with that. The purposes cited by the court included motive, state of mind, and the evidence was admitted for those proper purposes.
But it didn't include the whole bundle of sticks. And the way the evidence came in under Ferraro, the jury could use it for any purpose whatsoever, correct?
I believe so, yes.
And you've conceded that that was not right.
Correct.
That it only should have been for these limited purposes under 404B.
Correct, and it was properly admitted for those limited purposes and used for those limited purposes.
But without a corresponding limiting instruction that that's the only reason you could use that evidence.
I was unable to locate a limiting instruction in that regard. But even the absence of the limiting instruction would not preclude this court from affirming Stamm's convictions and sentences because he still has not demonstrated compelling prejudice.
And that's where you get to prejudice. And
yes.
You've been patient with me. Please continue.
So, again, the evidence would have been admissible in separate trials under Rule 404P. Stamm has not challenged those 404B instructions, as this court has noted. And Stamm cannot prove compelling prejudice because the jury was instructed to consider the counts separately, and it did so. He was found guilty of a lesser-included offense in the 2016 indictment and acquitted of 3 from the 2017 indictment. Thus, Stamm's claim that he was prejudiced by the consolidation of the case is unavailing, and this court must affirm his convictions and sentences with regards to that claim. If the court has no further questions regarding consolidation of cases, I'll move on to the admission of the jail calls.
Let me ask you, with prejudice, and
yes.
I'm in your wheelhouse now. So, but what could the defendant have shown that might suggest prejudice on this record or on appeal? You have indicated that didn't happen here, and I'm
Correct.
trying to figure out what it would have been. It's not post-trial juror interviews. We know that, right? Under 606, those aren't coming in.
I haven't researched that hypothetical, but I would have to go to case law and look at cases where this court found that a defendant had established compelling prejudice. I would be happy to submit supplemental
I'm not asking
citation
you.
to that. Thank you. So the trial court also properly denied Stamm's motion to suppress his jail calls because recording, disclosure, and use of the jail calls did not violate the federal wiretapping statute, since they fell under 2 exceptions: the law enforcement exception and consent. The state does disagree that the recording of the jail calls by law enforcement officers meets the definition of interception. By the plain language of the statute, 18 U.S.C. Section 2510, 5A2, a law enforcement officer's use of an electronic device during the ordinary course of his duties does not meet the definition of interception. It's exempted from that definition. And because in this case, the Maricopa and Yavapai County Jail officers were acting in the ordinary course of their duties, routinely recording these jail calls, they fall under the law enforcement exception. And because they fell under that exception, they were thereafter exempted from any other requirements pursuant to Title III. The state was not required to obtain a separate consent or waiver from Stamm to use or disclose those recordings. And the court may look at Wasserman, an Arizona court ruling, which found when the initial interception, in this case, it wasn't even an interception under the law enforcement exception, applies, no other limitations are applied to the disclosure or subsequent use.
The unsigned waiver in Index of Record 236 that Mr. Ray pointed out, you feel is really not dispositive, or we should take into our analysis at all?
No, because he was informed that his calls, all that is relevant was that he was informed that his calls would be recorded. He wasn't required to sign a waiver to waive that right or to give consent. Federal case law has clearly held that mere use of the privilege to use these jail calls when you're an inmate constitutes an implied consent to the recording of those calls. The second exception that applies here is the consent exception. Stamm clearly consented to the recording, and again, because an exception applies, the jail calls were not subject to any other limitations regarding the subsequent use and disclosure of the jail calls.
But what about the choice that Mr. Stamm had to make? I mean, he either didn't get to use the phones, or he got, he either used the phones and put it out there for possible recording and dissemination, or he just sat there and didn't use the phone calls. I mean, that's kind of a Hobson's choice that, not a lot of us would want to be put into, or Mr. Stamm was put into that, and so he should be somehow penalized for making that choice to avail himself of phone calls?
It's first important to note that inmates have no per se constitutional right to use the jail's telephones.
Is he an inmate at that point, or is he presumed
detainees
innocent?
Or inmates. Individuals who are detained within the jails have no per se constitutional right to use the jail phone call, jail telephones, to make outbound calls. I can't recall off the top of my head, but one case stated that it wasn't even a non-constitutional right to use those phone calls. It's a privilege. And even Hobson's choice, where there's no real alternative, is valid in this context. Federal case law has made abundantly clear that the choice between not using the calls, the telephones, and using them is really only relevant if you have a right to use the jail phone calls. And in this case, Stamm did not have any right. And if he chose to exercise the privilege of using the calls, it was subject to his implied consent. And therefore, his consent was legally valid. Accordingly, the routine taping of the jail calls by the Maricopa and Yavapai County jails did fall under both the law enforcement and consent exceptions to the Federal Wiretap Act. The state also notes if the court finds that the jails were not acting under color of law, Stamm's consent would still render the admission of the jail calls proper under the Federal Wiretap statute. If this court has no further questions, the state respectfully requests that it affirm Stamm's convictions and sentences.
Thank you, Ms. Garcia.
Thank you.
Mr. Ray, we've decided that we'd like to give you we took up a lot of your time and questioned you fairly vigorously, so as a, I don't know if this is really a gift to you or a punishment, but we're going to give you 2 more minutes for rebuttal. So if we could put 2 minutes on the clock, we will give you time for rebuttal.
As I've been waiting, I've been pondering your hypothetical, Judge Thoma, the megaphone in the Suns Stadium and so forth. And again, I have to come back to the point that is placed in this Hobson's choice. You either get to make a phone call, you know that it's going to be recorded, but if consent has any meaning under the Conyers decision, under other, mostly in DUI cases, as I've noted, but consent issues, it always comes back, in my opinion, to what was the scope of the consent that Mr. Stamm in this case gave. If he did not sign the document that said, I consent to your divulging this to anyone, including the county attorney's office, then we would not have this issue. But because he didn't sign it, then we have to look, all right, what was the consent that he granted? And it was defined by what was on the recording. This call may be monitored or recorded. That was the scope of his consent. He did not consent to anything else other than monitoring and recording. We know what the monitoring and recording purpose is for jail security reasons. The state has so said in its brief. You then look to the controlling federal statute, and I say it's controlling because it is very clear to me under 2515 that the federal government intended, the federal legislature intended to control this area. And if they say that it's not to be admitted, it's not to be admitted. And you don't have to look to prejudice to Mr. Stamm. It's there. And so, and I've taken my time, and I apologize, judges, and I thank you for your courtesies.
Thank you, Mr. Ray. Thank you to both sides for your briefs and your presentation here today. We do appreciate it. It was very helpful. We will take the matter under advisement, and we will issue a written ruling in due course. At this time, the court stands adjourned. Thank you.